Thank you for joining us once again on the State of Freedom.
The State of Freedom is a listener-supported podcast. We're committed to pursuing the truth about policymaking, regulatory actions, and political maneuvers in Louisiana and at the national level that stand to impact your freedoms.
Please support the State of Freedom by becoming a monthly supporter or member of the Warrior Circle, or by advertising your business, your nonprofit, or your event with us. Go to freedomstate.us. We are bypassing the mainstream media cartel and the establishment political parties in Louisiana and coming directly to you, spreading the uncensored voice of freedom across Louisiana and beyond. Red Zeppelin is the best kept secret, but because of us, it's really not a secret anymore. Anybody who has not been to Red Zeppelin on Perkins Road in Baton Rouge, you're truly missing out. The best environment, the best service, and the best pizza in the state of Louisiana. Go to Red Zeppelin today. Tell them the State of Freedom sent you.
All right. Well, the Supreme Court just handed down a series of decisions over the last couple of weeks that will shape election law, executive authority, immigration enforcement, privacy rights, and federal agency power in the United States. These are not isolated rulings. Taken together, they reflect real shifts in how the court is defining the balance between government authority and individual rights. And today, attorney Paul Hurd joins us to break down what these decisions actually mean legally, practically, and politically for the country, for Louisiana, and for the future of the rule of law. I'm Danielle Walker, and I'm joined by my friend and co-host, the watchdog in chief of Louisiana Citizen Advocacy Group, Chris Alexander. And on this Thursday, July 2nd, we are coming to you live on Voice of the People USA TV and radio network on Rumble, X, YouTube, Facebook, probably more places than that. We are so happy you're joining us today. Take a moment, hit the thumbs up button, and share it with your friends. And if you would, also consider joining us in the Warrior Circle. You can visit join.freedomstate.us to do that, and it will keep the voice of freedom alive and well in Louisiana. And you can also catch us later on our audio-only platforms, usually later in the day. Let me bring forward Paul. Morning, Paul.
I'm here.
Thanks for joining us.
Glad to be here. Happy 4th of July, 2 days early.
Happy 4th of July. Happy 250th birthday, America.
Amen.
Absolutely. And there's really not a better person to have on the show on this occasion than Paul Hurd. I mean, could we have anybody any better? I don't think so.
That's right.
I don't think so.
Well, if big, old, tall Uncle Sam walks in behind me, we'll let him speak.
Well, he's awesome. Probably the only one that could overshadow you, Paul.
Oh, that's nice. Thank you.
Look, gents, let me get into the scripture of the day, and we'll take it from there. But today's passage is in 1 Corinthians chapter 9, verses 25 through 27, and it says, "A true athlete will be disciplined in every respect, practicing constant self-control in order to win a laurel wreath that quickly withers. But we run our race to win a victor's crown that will last forever. For that reason, I don't just run for exercise or box like one throwing aimless punches, but I train like a champion athlete. I subdue my body and I get it under my control so that after preaching the good news to others, I myself won't be disqualified." And as believers, we're running our race realizing that it has eternal consequences for us and for those that the Lord puts in our paths. So how much more than non-believers are we supposed to be making sure that we discipline our minds, our mouths, and our bodies? Paul is explaining here in his letter to the Corinthians that it's of the utmost importance to him and how he was living his life, that his words and his actions agreed, because he didn't want to be one who preached the gospel of Christ's kingdom and then fell short of qualifying for eternity himself. Another way to say it is that in our time, God's grace is often overemphasized and our responsibility to allow ourselves to be refined by the testing of the Lord's fire. Our responsibility to self-discipline that aligns with the life of Jesus is underemphasized. Both are true, but let us not favor grace to the point that it undervalues the suffering of Jesus. Paul points this out several times in his letters to the churches, but it's very clear in Hebrews chapter 10, verse 26, where he says, if we continue to persist in deliberate sin after we have known and received the truth, there's not another sacrifice that can be made for us. Essentially, he's saying that we can reach the end of the road of grace if our hearts are not right and trying to reattune to the Lord. So my encouragement and challenge to all of us today is that we invite Holy Spirit to help us examine ourselves and see if there are places where we need to stop taking advantage of the Lord's grace and instead commit to greater personal discipline, so we are not ourselves disqualified.
Yeah. In other words, Danielle, let's always focus to make sure that our actions on a daily basis are consistent with our words. On a slightly in a different part of Scripture, what you said reminds me of the passage, and I can't remember exactly where it is. Maybe it's in Matthew, where it talks about making sure that we don't have a plank in our own eye as we're trying to remove the speck from our brother's eye. In other words, make sure that we ourselves are doing everything that we can to live the gospel and to be persistent and persevere in God's grace, so that when we do speak to others about the gospel, it truly resonates, and there's consistency between our words and our actions, and it's very important because what we do here, as you know, does have profound eternal consequences and repercussions. So, but what we do here matters, and today we're here to talk with Paul Hurd, legendary constitutional attorney Paul Hurd, about what the Supreme Court has been recently doing here, and there's no one better to talk about it than Paul. Paul, thanks for being here with us. You really don't need an introduction here anymore, sir.
No,
well,
that's
it's
true.
a great morning to be here. We can say that the Supreme Nine have been busy, if not perfect. Yeah.
Busy, if not perfect. Yes, I like that.
And Paul, I do have a meme that I'd like for you to react to before we get into SCOTUS and some of those decisions. So you can give us your take on whether you agree with this or not. Let's see if it's big enough for you to see. Maybe we can put it up like this. Can you all see it? I'll try and put it so we're in the corner here. How about that? Okay.
Let's see.
So call them out for the people who are just listening, Paul.
Oh, the description for those that don't have video, it sort of gives you a running characterization of the 9 Supreme Court justices, and I would go more, since I'm a lawyer and sometimes have to deal with people in road.
Should I call it out then?
No, I'll read anything.
Okay.
I won't. Look,
You're not going to comment.
Gorsuch is conservative. Wait, the leader of the pack is Justice Thomas, and that's probably absolutely true, unless Justice Alito ties him at the finish line, and then Gorsuch is probably number 3. It says conservative. That's probably right. Look, the 3 on the way left, Sotomayor, Kagan, and Jackson, are all of a different persuasion. They are not conservative. They're not. They believe in a living Constitution, which means the Constitution is whatever our life tells us we ought to make it.
Yeah.
It's ambiguous. It's ever flowing with them. Whatever is the political scoop of the day, suddenly it is just found in some comma or sentence in the Constitution, and it can just as easily be gone in 20 years if they decide to change their mind. But the 3 that stay together, they talk about the other ones. Now, I've sort of ignored the big two in the middle, and that is Roberts and Barrett. And I just think the problem is that they have a heart bigger than their head, and they simply can't believe that status quo has value even if it's wrong, and to bring it all the way around full circle. I think the citizenship case is our new Roe v. Wade. I think what's going to happen is, the good news is, legally, academically, the citizenship opinion will be scrutinized as it should, and it will not stand up to historic, legislative, and actual intent. And so I think in that sense,
and on that, Paul, on that decision, Paul, Alito pointed that out. Yeah, and Alito, in a dissent in that, and we'll get to it. I think he pointed that out very, very profoundly in the dissent. Before, Paul, we get into some of these specific decisions, there have been a number of our followers who have asked us about the judicial districts in Louisiana, many of which have been drawn clearly according to racial gerrymanders. What does the Calais decision allow regarding the curing of these judicial districts throughout the state of Louisiana that are clearly racially gerrymandered? Can they be challenged? Will they be challenged? And what will happen in these judge districts throughout the state?
If those that have been drawn, and we all know, every judicial district does not have them, but for those judicial districts that have the intentional creation of minority sub-districts, they're unconstitutional. They just don't. It is awaiting legislative correction. Now remember, our benevolent governor was so kind to change our districts when he thought the federal judge in Baton Rouge told him they were wrong, and so he created a racial gerrymander. It took us 2 years to set it aside. Perhaps he'll realize that if he doesn't fix this, it's clearly no longer a valid election structure. And so I think the question's going to be, how do we elect our district judges and appellate judges? And our Louisiana Supreme Court is very, it's newer. It was jimmied a little bit recently. I believe it still has the same problem that we had in Calais. And so I know the district courts and the appellate court level, the middle level, they all have the problem. The problem's going to be, how are you going to elect judges? Because the only thing I think worse than elected judges is appointed judges. And so true. But when I wrote a book on reforms for Louisiana 20 years ago, and it's got 3 or 4 structural strategic suggestions on how to yield a better, predictable, big head, small heart judiciary. And I think we're going to have to readdress those issues because I think we need to retain elections, but we also need to vote together. Calais did not say one race gets to dominate another. What it said is, we live a life today in America that is nothing like the 40s and the Jim Crow of 20, 30, 40, 50s. We are an integrated society. We live together. We go to school together. We love together. We marry each other. The racial fear of one another is something that is luckily largely behind us, and at least legally, institutionally, is unacceptable.
Absolutely.
But we're going to have to figure out how to elect judges. And I think a lot of it is going to go to quit electing lawyers whose minimum requirement is to be 5 years a lawyer.
I couldn't agree with you more, Paul. I
can't
could
raise
not
my hand.
absolutely agree with you more there. I think that there absolutely have got to be more stringent requirements imposed upon lawyers before they can even run for judge. You have so many of these lawyers who run and are elected a judge who couldn't find the bathroom, quite frankly, inside of a courtroom, have never tried a jury case, who simply do not understand all of the nuances that go into this. I could not agree with you more. I think there should be more robust conditions imposed upon judicial candidates. But to the point of the racial gerrymander, how important is it that this issue be handled legislatively in the upcoming legislative session?
We've got judicial elections this November.
Okay, so can we? So what can he call? Could the governor call a special session now?
Any candidate that wants to challenge them simply needs to challenge them, and I think they will. What's going to happen is you'll challenge them. The courts, because it's a hard question, they'll say, "Okay, what's your solution now?" And either we'll immediately go to full judicial district at-large elections, or we're going to say, we don't know the answer, we're going to let them do it one more time, but by filing the suit, everyone who benefits from an election that occurs after the lawsuit is on notice that they are in a position that may change. And so I think in a sense, I cannot believe in a state of 4.25 million people that someone's not going to run justifiably to a court and say, the U.S. Supreme Court says we are not going to allocate political power based upon racial proportionality, and these districts have to end.
And they Paul, have your number. And they have your number, or probably should have your number.
Who would you say qualifies for standing to bring this kind of case forward?
Candidates or voters.
Okay, so basically everybody.
Calais was voters. We weren't candidates. Those plaintiffs have their right to elect a judge, have their voting right impinged upon by a racial designation of beneficiary. That's Calais. You don't have to be a candidate, and you have to find, we were talking about the uniparty members in the world. It's hard to find a lawyer who wants to sue every judge in Louisiana. Okay, let's be honest about it.
Yeah.
Why don't you go jump off a cliff? Or look, I had the same problem when I did I won the first racial gerrymandering case on the merits in America in 95. First one, and everybody told me, you're crazy, and everybody will hate you. And as it turned out, truth protects a lot of integrity, and it's worked out real well. We won the first one here, and I was involved in co-counsel in the culmination that Shaw finally said equal protection means equal protection for voters. And I think we're going to have to develop a structure of how do we elect judges other than majority, single district, single seat elections. Because if you do that, the same majority, we have 12 district judges in Monroe, Morehouse, where I live. We have 12 judges. If you do designated Judge A, Judge B, Judge C, and you require a primary, and then if someone doesn't get 50%, you require a runoff, so whoever the winner is has 50% vote of the voters, then you will be going back to where we were. And I don't think there's anything in Calais that would suggest that a racial manipulation of that structure will be tolerated.
Yeah. Well, Paul, maybe we shift gears here a little bit because I know we have a
Sure.
lot of ground to cover. This Supreme
It's
Court
been a
has
busy
made
2 weeks.
it has been a very busy 2 weeks, and I thought we might start off from here on two cases that kind of touched on presidential or executive power and agency independence. So they were Trump v. Slaughter and Trump v. Cook, and Slaughter was the one where Trump was trying to fire someone who worked for, believe, the FTC. She was a
FTC.
commissioner of the FTC, and the other one was Lisa Cook, who was alleged to have some pretty significant mortgage fraud, I believe, but she's a governor of the Federal Reserve.
She's on the board of governors of the Federal Reserve. And she's been appointed for 14-year term. She's only, I think, she was 2 years into it under Biden, and she's now, a year and a half under Trump. So she would have over 10 years left on the board, depending on the authority of the president. The executive, whoever the president, whether it's Biden, Obama, Trump, George Bush, it's a question of our Constitution having three branches of government. We know them: judicial, legislative, and executive. And there's no third branch of government. And that's the problem that Congress started creating, in quotes, independent agencies, which meant they were telling agencies to govern certain things, EPA, Federal Trade Commission, and saying, but the president can't make you do what he wants to do. They called it independent only because it was totally, now we know it's outside the constitutional structure.
Yeah.
And so what Slaughter said was, for everything except the Federal Reserve Board, okay, let's just leave them on the side. It gave the president, as the chief executive officer, the authority to appoint and remove, out with the old, in with the new, and be able to administer his administration with his servants that he wants.
So Congress cannot create, cannot give these broad grants of power to these executive agencies, statutory authority, and at the same time try to limit the president's authority over those executive agents. So the Supreme Court basically is saying that the president does have ultimate and plenary authority over every executive agent, every executive employee in the country. Correct? Is that what's going on here,
Well,
Paul?
you do at the executive, at the management level. Let's not forget civil service type authority for, in quotes, those who are below management. But those people still have some protection, and that is a real tough group to change their mind. The other thing that the independent agency had created is what we call the administrative state in this sense. Congress would not legislate specifically. They would hand over environmental concerns to the EPA. You couldn't change who led the EPA, and they let the EPA, through rules, enact law. And so what happened was the voter had no control over this administrative estate that, once appointed, was almost truly independent of any democratic or executive supervision. And that's largely been peeled back.
Yeah, the Chevron doctrine you're talking about. Yeah, the Chevron doctrine. We had Mike Johnson on.
Let's go to the Federal Reserve Bank.
Yeah.
It is now, I don't necessarily agree, but this is what they say. All of those agencies were exercising authority that ultimately were authorities that an executive, a president, would have. Executive authority. Now remember, lawyers make exceptions so we can split babies. We're going to say the actions of the FTC are executive, therefore the president can replace them. the Supreme Court, were not ready yet to say that the Federal Reserve Bank is exercising, in monetary policy, is exercising a power that belongs with the executive, that it's almost sui generis. It's independent. It's an issue, an operation separate from normal government. Now, golly gee, if you say it 3 times doesn't make it so.
That's right.
But that's where we are now. The other thing to remember on Cook, that's the one that, for the time being, looked like it let her stay on her position. There is an allegation against her about mortgage fraud. Good or bad allegations, nobody knows yet. The narrow holding of Cook was only that whether or not for cause limited the president's ability to not appoint her back or to remove her, and that she got no opportunity, due process. What is due process? Notice of the complaint and an opportunity to respond, versus I don't have to tell you why.
Yeah.
He chose a for cause discharge. He didn't try to say, like he did at FTC, he said, I don't have to give you a reason. You're gone. Now let's go see the Supreme Court. That issue went the president's way. The question may be that he goes back down, and for the lady at the Federal Reserve Board, he simply says, I'm not doing this for cause. You're gone. And Slaughter says I can remove you.
Yeah.
And so it was a very narrow holding. Don't let people tell you that the Federal Reserve Bank is still protected. It is a little bit unique, but don't put those glasses on now.
Well, yeah. Paul, quick question. So the bottom line is, Miss Cook is still challenged. So she's challenging this. She's in the process of challenging this at this point. And so that was part of the ruling also. There has been no ultimate disposition regarding her case, right?
The merits
of her case.
The merits on can you be discharged under what circumstances.
Right.
The merits were there at that level. They already had gone through it at Slaughter. So they decided on Slaughter that if you're a member of that agency, he can fire you. The case on Cook was narrow on only whether or not she could keep her position while she litigated.
That's the point I'm making right there.
That's exactly the point. They never got to the merits.
Yeah.
In fact, one of the issues we don't need to get into this is lawyering, but one of the issues to maintain an injunction that has to be proven is likelihood of success. They let her keep the injunction to, in quotes, another provision is preservation of status quo. Well, They certainly issued an injunction to preserve status quo because the authority of a president over the Federal Reserve, in contradiction of a statute. Now remember, this isn't a choice. This is a whether or not the creation of a statute by Congress that says they cannot be removed is unconstitutional. Otherwise, Congress has the authority to legislate as long as that's within the 3-branch of government constitution that we have.
Yeah, that we have.
But it was, Slaughter was general, was broad, was a final issue. Cook was a Federal Reserve Bank, was very narrow.
And I think it's a very, very important distinction to make, that distinction right there between those two cases.
We shall be back.
Yeah, we shall be back. What about, Paul, the Watson RNC case that upheld Mississippi law allowing mail-in ballots to be counted and included up to 5 days after an election, as long as they're postmarked on election day? What are your thoughts on that? And if and it was basically if they had sent up a law that said you can't. If we haven't received a ballot, if Mississippi law was we haven't received a ballot by election day, we can't count it. Would the Supreme Court have affirmed that? What is your opinion on this opinion?
Oh, that's exactly what they said. They said, one, the question was whether the election day statute that was federal, which wins its supremacy clause, did it say that that ballot had to be in the voting officials' hands by election day? Did the term election day mean that ballot had to get there? And they simply held statutorily, one, the statute says nothing about receipt of a ballot either way. It was enacted while absentee voting was permitted. It was a known practice. They said silence meant that the statute didn't intend to address received. Therefore, and the way the election law works, states run, you'll hear them say states run elections, except the feds have overriding authority to set any terms of an election, procedures of elections, that the state then must have to comply with.
Right.
What the Supreme Court simply held was the federal statute did not expressly mandate receipt by election day.
Right. So this, yes. Yeah.
The states can tighten it up like Louisiana did. We say if our clerk doesn't have them, or register a voter, but if our clerk doesn't have them in their hot little hand by 5 o'clock on election day, they don't count. That's what our law says. California says if you'll send it to me sometime next week, it's
right.
probably okay too.
Right.
Or go fish out one.
Yeah.
And
yeah.
Look.
So this was a matter of statutory. So Paul, this was a matter. This Mississippi case was a matter of statutory interpretation, and you think the Supreme Court really reasonably and accurately interpreted what the law actually provides.
The good news is it said, Congress, if you want to make it that way, make it that way. We have no evidence that you had expressly addressed the issue of receipt. If you don't like it, fix it. But the good news is, and the only good news on this is that we have a Supreme Court that is leaving these decisions in the hands of the political branches, where we can elect people or unelect people. We're never satisfied. We all wish we could run and be king for the day. But the answer is, if we make it, what's the Supreme Court going to do? Is tell Congress what Congress intended?
Exactly.
Right.
I would rather they make this narrow decision and say the statute didn't address it. It could have and did not.
So they did their job. They did their job on this.
Think about this case and think about the transgender athletes that we're going to talk about. Both cases basically come down to, if a state protects you, the state has the authority to protect you. Protect your ballot, protect the biological women from transgender crazy athletes. The state has the authority, but the Constitution, nor any federal law, compels those protections in more detail. It is state authority, and we have 50 of us.
And that's why so much of this, Paul, so much of this comes down to our state legislatures and what we do and who represents us in those bodies. So much of this comes down to that.
We are a democratic republic, and we get as good as our representatives give us.
Absolutely right. What about, Paul? Let's talk about the NRC, I think, the FEC case. Basically, it was the case that came down that said, under the First Amendment, the Supreme Court says there is no limit on the amount of money that can be spent where political candidates coordinating with established political parties. No campaign limits, no money limits, because it violates the First Amendment. What are your thoughts on that one?
I think that one was inevitable. I mean, certainly if corporations have the right to make all the contributions they want certainly the political parties have to, and I think you get more disclosure if the money's coming through the political parties. It doesn't say they can't require disclosure of who's making the donation, but through the political party, they're now saying, and look, I think they looked up, and money is fungible. If I want to help the Republican Party and I want to help a Republican candidate in Kansas, I can give the party $100,000 and they can go spend it on the representative in Kansas. Or what do we do today? I split my $50,000 to the Republican Party, and I give my other contribution directly to the candidate. And I think the Supreme Court knew this was all bookkeeping, and in fact made it simpler under the First Amendment to say, go advocate who you want, disclose who's supporting you, and again, let the voter decide. Now, the voter needs the disclosure. I don't think on voting that we've had any cases that the Supreme Court has limited the government's ability to mandate disclosure of who gave the money. Yeah. Other than that, as long as I know who gave it and then to whom he gave it and who's spending it, peace be with you.
Yeah.
Go on and elect a representative.
Of course, we have the problems with all of the super PACs that are not directly aligned with the campaigns or with the candidates, whose donors can be anonymous. So you don't really know who's donating on those fronts, and we're talking about millions and billions of dollars there.
But the good news about this case may be the reason the super PACs came into existence was because they couldn't just give it to the political party
without disclosure.
Well, not only now, disclosure is a different issue. You're right, but they couldn't give it to the party because the party couldn't help the particular candidate. The super PACs became the vehicles by which money in excess of what you could give to the Louisiana Republican Party that would help Letlow or help Fleming. Once you hit that limit, if you wanted to give more, the super PAC was created to say you can't stop me. Now,
right.
The one thing left with super PACs now may very well be disclosure of contributors, because part of this decision eliminates some of the reason to send the money to a super PAC, except for what you mentioned, and that is to impact an election and no one know where the money came from. And,
yes.
And I think that will be fixed now that the money can go to the parties in unlimited amounts.
That is a great point you make, Paul. And I hope that is the result here, because we're talking about $6-7 million more probably in this race spent by super PACs whose donors and whose funders are entirely anonymous to citizens in the state of Louisiana.
Absolutely.
I think that is a real issue. It's a real issue.
Oh, it was embarrassingly dirty.
Yeah.
And is that an issue you expect to be the next one to go to SCOTUS on campaign fundraising? Then
well, they first got
perhaps
the only way to mandate disclosure would be, first you need a law, and be interesting. Either way, the answer is the only way we get to SCOTUS now, if it's undisclosable now, it'll stay that way until a law changes. I don't think there's anything that constitutionally mandates disclosure. I think it has to be, is it a regulation that does not interfere with the First Amendment? Now, let me mention something historically, just so ironically. One of the first cases that came out that said that you could make a contribution to an organization, a nonprofit organization, for political reasons, were to protect the donors to the NAACP who were donating to them to support the elimination of Jim Crow. It was necessary to prevent retribution against those who were in favor of segregation. So it's got a the non-disclosure into a group's whose agenda is well known has a historic background of non-disclosure allows those contributions for communists and for free capitalists. The question is, maybe the First Amendment says the voter needs to sort it out.
And it sounds to me like the historic precedent allowing the non-disclosure, Paul, perhaps no longer exists, and that requiring disclosure, even from these super PACs who currently are not required to disclose, perhaps is consistent with the First Amendment. In other words, it's not inconsistent with the First Amendment to say, look, you can donate as much as you want, but the voters and the citizens have a right to know exactly who you are.
Oh yeah, who is advocating this position?
Yes. Beyond
the generic named organization that disappears as soon as the election's over.
Exactly.
Yeah, I think that's where it'll be interesting, but it's going to be hard to get a constitutional obligation spontaneously. The question's going to become, once you get a law that says it's got to be disclosed,
right?
Whether or not that can stand going forward.
Yeah.
All right, this is like Jeopardy.
Well,
I'll take transgender.
You'll take the next one now?
Well, we're on the birthright citizenship now.
All right, let's do birthright.
That's right. Yeah, so Paul, before we get into birthright citizenship, I want you again to react to some great memes by the fantastic the fantastic minds at Babylon Bee. Here's one. Let's see here. It says, Supreme Court rules any baby born at Olive Garden is an Italian citizen. And then the other one I wanted to share with y'all is this one, which is also, I think, hysterical. And it says, winning, Trump now rules the entire world as Supreme Court declares that everyone is an American.
Yeah, we do have our world emperor now.
Wow. Well,
do you want to talk about the outcome of this, Paul? Because I was very surprised to see how this one landed. I thought because we'd heard some rumblings, I believe, from Alito on this. I believe that's who it was, but I could be mistaken. A couple weeks ago, that I really thought that maybe we would come down with some stricter rules around who's considered a citizen, and really to get rid of this anchor baby situation that is just kind of destroying culture.
The transitory birth inside our geographic jurisdiction didn't seem to be adequate enough for a citizenship designation. But look, the only good news about the opinion by Roberts was he made it real clear that if you sneak into this country, you don't belong here. You came on a visa to visit Disney World. If you go on and have a baby, you get Disney World memories and you get citizenship. And it's a.
Is that so crazy?
Well, it's a. All right, we know where we are. All right, the question is, I think this, and I've said this in other forums, I think this is the Roe v. Wade of this term. And the simply is, there were a couple of different outs that the day may come that this opinion can get narrowed down jurisprudentially, legally, constitutionally. One, we have the 14th Amendment language. Born in America and subject to the jurisdiction thereof. All right. Our court took the the broadest language or interpretation of jurisdiction, saying, well, if you're subject to a speeding ticket, you're a citizen. I mean, if being born here and being subject to our civil jurisdiction meant the same thing, it's redundant. Because if you're here, you're subject to the criminal jurisdiction. Historically, that meant much more. But the point is this: we do that in after the Civil War. Then the Congress in the early 1900s enacts a citizenship statute that says, by that time, the interpretation that jurisdiction limited almost nothing had taken blossom in the liberal academia of the world.
Yeah.
If Kavanaugh invented this, it's in his opinion, it's a 5-4 without Kavanaugh. You still got Roberts and Barrett, and then you've got the three liberals. All right, that's 5. Kavanaugh concurred in the opinion, but said he did because statutorily the Congress enacted a citizenship provision. For example, Indians were not originally citizens of America because they were loyal to another sovereign, their tribe. It created statutes that create what we call statutory citizenship. Kavanaugh said he concurs that these people are people on tourist anchor babies, on illegals, babies. They are citizens because of the statute. But what does that mean? It means you can change it.
So in other words, Kavanaugh, if he got, he
needs to flip one person.
Exactly. In other words, he would not rule a congressional statute that outlawed birthright citizenship unconstitutional necessarily. He's basing his concurrence on the fact of the statute, correct?
But not only this, it's exactly the same language. That's the interesting part. But remember this, the question was, when it was enacted in the 1800s, was it meant to be narrow? Maybe it was. But by the time they enact the same language, and this goes to legislative intent. What did the legislature think in the early 1900s when they enacted the same language in a statute? And what he says is, by then they thought it was broad. So therefore, the legislative intent was a broad definition of letting people in.
Right. Needless to say, they could not have possibly envisioned what we're dealing with now.
Could change it.
But they could, but they obviously could not possibly have envisioned, I don't think, the situation that we're dealing with now in our country, which is, just subject to horrendous abuse. But I want to read I want to read just part of Alito's dissent here,
Sure.
Paul, and get your response to this. He says, this is one of the most important decisions in the history of the court, and in my judgment, the court has made a serious mistake and one that will seriously affect the country's future. The 14th Amendment confers citizenship only on those children who at birth owe allegiance solely to this country. And then he goes through the history of the debates on the 14th Amendment, and that is his conclusion. Do you agree with him?
Oh, I think that's why this is a Roe v. Wade type case. I agree that, interestingly, when Supreme Court, this opinion on both sides with all dissents and concurrences is 194 pages of condensed technical legal writing, 194. It certainly wasn't a simple question. And what he is saying, one thing that's another weakness of the Roberts opinion is that he doesn't address the history of this language and the legislative intent when they enacted the constitutional amendment. He just simply skips to it, and more or less, and this goes back to sort of our initial meme on this, and that is, they were willing to say the Constitution was settled because today in academia, the settled reading was that as long as you get over here or get to Guam, get to Puerto Rico. I mean, if you're from China, you don't have to come to California. Just go to Guam
Right.
or American Samoa. Drop that baby in the harbor and go, then go fishing, and you got a U.S. citizen. It's a bizarre idea that the legislature would be that slipshod with the value of its citizenship.
Yeah. Yeah.
And so anyway, I think that's why if all they did was rework their opinion to say this is not required by the Constitution itself, but it's something. Now, I'll play lawyer. If you ever hear this being said, we're moving in the right direction. The Equal Protection Clause has what's called Section 5 that allows Congress to implement the 14th Amendment. That's what created the Voting Rights Act, was the authority of Congress to implement equal protection under the Voting Rights Act. Okay? They did. Now, that same Section 5 gives Congress the authority to implement the citizenship provision in the 14th Amendment just as well. And when they start talking about if Congress clarifies, that's a good word, and implements a more detailed explanation of what it is to be subject to the jurisdiction or not subject, I'm filling in the blank. When you start hearing them talk about Section 5 of the Voting Rights of the 14th Amendment, and you hear them talking about statutory citizenship, this decision's on its way out. But until then, it's not.
So obviously, we have to rely on the Congress, on the U.S. Congress, to write more robust legislation that more clearly defines these terms and restricts the type of abuse that we're seeing here, whereby someone can come into the country, have a child, the baby's born here, they leave, and that child is an American citizen. I cannot help but think that our original founding fathers absolutely could never have envisioned that being the case in the United States of America, Paul. I just can't see it.
Oh, I agree. But here's what's interesting or better about that solution, and that is there'll be a day that statute is enacted, and that day is the day that the baby born in Guam's harbor is not a citizen. The one born the day before still is. You've got a date at which the clarity of citizenship can be defined. Part of the problem, now I'm going to just mention this. The reason I'm on the other side, I think they did wrong. They talk about this Juan Will Ark case. That case was Chinese immigrants had come here, had green cards, and were permanent residents of America. They were legally here. They have a baby here. He goes back to China. When he tries to get back in, they won't let him in. They say, no, you're not a citizen. The point of it is that's nowhere is that analogous to the illegals or the temporaries. That case has always been used as an excuse that says if you're an alien and you have a baby, then that baby is a citizen because he's born here. It doesn't matter that you're an alien. That's not what they. So again, I think if you look at where we are, this case could easily be reconsidered and narrowed to the point that you may not even need, again, you may not need legislation, but at this point, the statutory citizenship may be what's really surviving because Congress did it. And now the question is, can Congress change it and the president sign it before before anything changes?
Well, and I doubt it. Unless our elections change, unless our elections are fixed, we can't expect Congress to do anything at all whatsoever, because this Congress is doing everything in its power to destroy the country. But I do believe
Well, we
that
can't get them to pass the
perhaps we
SAVE
will
Act,
see
Danielle. We can't get them to pass the
Well,
SAVE Act, Danielle.
I'm just saying, Chris, that I do believe that Trump is going to do something on this, because he said that he will do something on this with or without the SCOTUS. And so to me, if what Paul is saying is on point and the way to do something without SCOTUS, then he's going to have to get our elections fixed.
Well, no, but think about this. At least as it relates to visas, as far as baby tourism, he controls immigration. The president controls immigration, and I think I saw where he's instructing the immigration department to look at what rules and regulations can they implement to simply make sure that pregnant, expecting aliens don't get visas. You can't come in.
Yeah.
And that way that baby won't be born here. And remember, one of the cases that they recently issued was whether or not, when a illegal presents himself at the border but does not get in, the stay in Mexico provision, they said, well, once you present yourself, it's the same as being in America. And the Supreme Court said no. The statute says you only get to apply for asylum if you arrive in the USA. He can do the same thing with visa restrictions, and they never arrive in America pregnant. Therefore, the short-term birth of alien children in some geographic location can be substantially prevented.
Yeah, in other words, a lot of this problem could be handled on the front end through robust immigration enforcement, and that's an excellent point, Paul. I agree with you there.
And I think
obviously needs to be.
Tourism can be handled. The problem is the pure unrestrained illegal aliens in America right now got a free pass.
Yeah, it's unfortunate.
Until they change the statute. Now, the good news, I say, change the statute, because if we can barely pass a federal statute, I don't think we're going to amend the Constitution. Yeah. It takes, 2/3 of both houses, and then you need 3/4 maybe of the states. And it isn't going to happen.
I want to ask you, Paul, Danielle's got one more after this, but I want to ask you about this Chartry decision related to the Fourth Amendment. You know, I think it's really interesting from the perspective of criminal defense. The Supreme Court ruled that these reverse location, what's called geofence warrants, where they do these broad sweeps of people's cellular data who are in the general vicinity of a crime scene, even people who are not involved in the crime at all, violates the Fourth Amendment right of privacy. What do you think about that? You have this, the big crime scene, and you got these, these broad digital sweeps being done of people's cellular data and cellular information, even people for whom there exists no probable cause that they committed a crime. The Supreme Court said that violates the Fourth Amendment.
Well, by making it a Fourth Amendment search, then the only way the phone company can be obligated to give the information is with a warrant, and a warrant requires probable cause on a particular person. So what we've got now, think about two different circumstances. This case, there's a bank robbery. They take $150,000 in cash. He escapes. They can't figure out who he is. After a full investigation, everything they had, the perpetrator had absolutely been able to, on traditional methods, no fingerprints, no video, they could not find him. They thought, well, let's ask the video, not the video, the internet and cell phone provider, tell us every phone that was inside within 100 yards or 200 yards of the armed robbery during the half hour that the robbery occurred. In other words,
Right.
they knew exactly when it had occurred. They knew exactly where. And they said, give us the list of every phone within that. And parenthetically, for all you criminals out there, if you're ever going to go rob something, please let me suggest, if you want to stay at home, that you leave your phone at home.
Right.
Anyway, what this one did is
Might be a good idea.
they identified, I think the opinion said like 39 people. Well, some of them were bank employees. Some of them were residences next door. They get down to about 6 or 8. And the perpetrator ends up one of the remaining ones that could not be easily excluded. They did follow up on him. Now they finally knew who to look deeper into. And they looked deeper into him, and then they based upon this geofence, and we don't know in this case, and based upon other information, they then got a warrant for his home, found the gun, found 100,000 of the 150,000, and found the mask that he wore. All right, so they got the guy. This is a classic. The guy, you got the right guy, and they would never have found him but for the geofence. And that sounds good. Go to January 6th when they asked for the same information around the Capitol, and then started pursuing as criminal charges against all the people that were there protesting whether or not they went in the Capitol or not. So it is a powerful technological opportunity. And the question was whether or not we individuals have a right of privacy as to where we were at any particular time. And the Supreme Court said, yes, we've got a right to that privacy. Remember this, reason they can search cars and they can seize your bank records is because they say you do not have an expectation of privacy at those locations. You've turned your papers over to a third party, so we got a right to take them without probable cause. You've got, so this is, once they said you have a right to an expectation of privacy, it meant that the information couldn't be taken except with a probable cause to seek that information. So you had to have something before you could go get something versus the right to simply go access all the technological monitoring of our lives today.
I think it's a very, very good
From
decision.
technology.
And I think it's a very good decision and a
I
solid
do
decision.
too.
Yeah.
Do y'all see a rash of suits coming out after this opinion from like J6ers, for instance, Paul, or from people who were put on perhaps federal watch lists?
Well, I think you're going to run in, those that are on watch lists now have a claim. Those that has already passed by, they could have made, the way it often works is you could have made your claim, you didn't, so you waived it.
Right. Right.
But it's
Okay.
but it certainly would, anything pending in appeal, anything like that, that would work. And it
In
might
other
even
words, about
work to
statute of
justify,
limitations.
it might even work to justify a pardon. To say that they violated my constitutional rights to access my phone locations, and therefore all the evidence that was gathered was fruit of the poisonous tree, if we can say it that way, and therefore there was no basis for the conviction, and therefore we pardon you.
Yeah.
And so
Wow.
it will be presented in various forums, and we'll see how it shakes out.
All right. Well, just to round it out, Paul, I think we'll round it out with one that you have already mentioned, at least in passing, which is the transgender one. And the question was, do state laws banning transgender girls or women based on biological sex from participating in female school sports teams violate Title IX or the Equal Protection Clause? And the courts upheld, or the SCOTUS upheld the state bans.
And this is like the voting case. It's this: the states have the authority, the discretion to enact laws that will exclude trans men from biological female sports. It doesn't say they have to. California can even mandate that they be allowed, but that's a different case. What they're saying is those states that will protect transgender females by excluding, protect biological females by excluding transgender males from participating in female sports, they have the authority to do that without violating Title IX or the Equal Protection Clause.
And so there's no danger, Paul, no danger at this point of Louisiana's statutory scheme from 3 years ago banning, biological men from women's competitive sports. It's over. There's no possible way that can be reversed at this point.
Well,
right?
Don't ever say no possible way. But the answer is this opinion appears to say that it doesn't violate federal law. All right, so we're there. The question it did not answer is, what about the biological female athlete in California? And she is competing for the high jump in the state track meet, and she loses to a biological trans man. And does she have a right to be protected from him? In other words, is it discriminatory to not protect her? And that's the next question that's going to come up. And it's going to be an athlete, a female athlete, out of a state that refuses to prohibit trans men from playing in women's sports. You probably are best off if you get a plaintiff that's been injured. I hate to say it.
Well, there was one, Paul, with the volleyball. I know there was one that was running all over the internet.
The boxing.
With the boxing, but
the boxing one to me would be the classic one. I don't know what geography that occurred in, and the one that I saw that was boxing was actually in the Olympics, wasn't it?
Yeah.
Anyway, be that as it may, you were going to find that they said, the commentary that I've seen says, look, this answered half the question. Whether you can choose to do it in one state. The next question is, for those states that won't affirmatively protect biological females, do biological females in those states have the right to protection? Are they discriminated against based upon sex as Title IX or equal protection if the state authorizes men into their sport? And
so what would your argument, Paul, what would your argument be on the latter point? A girl, you're representing a young lady who brings a suit alleging that she's being discriminated against because she was forced to participate in competitive sports against a biological male and her rights were violated. What's your argument?
My argument under Title IX is easy. Sex is sex, and he ain't a member of the right class. Now, under equal protection, you've got intermediary protection for sexual discrimination. In other words, you're allowed to mandate female bathrooms. You're allowed to mandate female preferences, and the simple point becomes, I think it would get there, but it's so easy under athletics that you don't, pardon me, you don't get to the issue for the female athletes. I think the federal statute will get you there.
Yeah. But a suit is inevitable, probably. A suit is inevitable, probably. Would you say?
I'll even say it this way. I imagine it's pending and been on hold somewhere.
Yeah, yeah, yeah.
And now, now it'll come back, be opened up based upon whatever those opinions, wordings, and writings say.
Yeah.
So we'll make a trip down that memory lane next year.
Well, we're looking forward to it, Paul. We can't tell you how much we appreciate your running through some of these big decisions with us. I know our viewers really appreciate the
I
clarification.
enjoy doing it.
Yeah. I think we have the best educated audience in the state.
Well, we're glad to be part of it. I enjoy your audience. I enjoy your shows, and I'm glad to make my contribution.
It's
Well, thank
always
you, Paul.
valuable. Always
Well,
valuable.
It
God
I
bless
hope
you.
so. I thank you for that.
And happy 4th of July to you, Paul, again. We will be seeing you soon, sir.
Yep, that sounds great. We'll be talking.
Take care.
Perfect.
care. Bye-bye.
Thank you. Bye-bye. Chris, great discussion today, and I think you're so right. Couldn't have been a better person to have this discussion with. And I think one of my key takeaways from our conversation today is simply what you said, which is I think we're seeing in real time, because of some of the way that some of these decisions came down, how absolutely critical it is to have good people in our state legislatures making laws that reflect the will of the people, because that's what some of these decisions came down to.
No question. Some of these decisions simply came down to the interpretation of statutes that had been passed by our elected representatives. And you're right, Danielle, that's why it is so important that we have people in elected office who pass laws that truly protect, in a very clear, articulable way, the citizens of our state and of our country. It is so important. So much of this comes down to what occurs in the halls of the legislature and of the U.S. Congress. It's vitally important that we elect the right people there, which is why the work that we do, I think, is so very important.
Yeah, I agree with you, Chris. And maybe just to round it out, then we'll make the suggestion or encouragement that people join the Warrior Circle. If you're interested in having some membership perks and really being a stakeholder in the state of freedom, we would love for you to do that. And you can do it at join.freedomstate.us. Let me pull that up. And then also, we want to make sure that you support LCAG as well. Chris's work is just absolutely invaluable to informing this podcast. So the two go hand in hand, and we want to make sure that you are supporting LCAG as well. And you can do that. Look, I'll put just both of those back up right here. And we'll try and keep those up during most of the shows. So if people are looking for how to get in touch with us, you can find everything you need between those two websites. Anything else on your side, Chris?
LACAG.org and freedomstate.us, the portal of truth that increasing numbers of Louisiana citizens, Danielle, if you look at our chats and if you look at the online responses are listening to, and LCAG, I think we are expanding very, very rapidly throughout the state of Louisiana. I'm thrilled to death to be partnered with you. And I just know that the next year is going to be the best yet, no question. Happy 4th of July to you, Danielle. We, even on the worst of days in the United States of America, we have so much for which to be thankful.
We do, and I think we're entering better days rather than worse days. So we have a lot to be looking forward to. And one last just reminder, Chris and I are taking off next week from the screen. So you will be in for a treat. You'll be catching some oldies but goodies, and we'll still have plenty of fresh reels out there on Facebook, X, and wherever else you might catch us. But we will be taking a little break, and then we'll be back the following week. So stay tuned, and we will be coming back with fresh content, fresh guests, and of course, our continuation of the legislative review for many, many topics. We haven't really touched as deeply on the MAHA as we would want to. I mentioned yesterday, we want to talk about campaign finance. There's a ton about legalized corruption and ethics that needs to be exposed greatly.
I
and
cannot
broadly.
wait for that one.
Yeah, we've got a lot to cover. So y'all just stay tuned, and by all means, if you're not following us on social media, do that. We're on Facebook and X and TikTok, so catch us there, and we will see you guys back here on the 14th live at 10 a.m. Central.
And happy Independence Day, Danielle. God bless.
Yeah, happy Independence Day to you too, Chris. God bless you.
Cabo Fuego, it's just unbelievable. Whether it's the flame-grilled carne asada or a signature mango margarita. I had one of those too. They're serving up a literal feast of freedom at Cabo Fuego. It's just extraordinary. I love the owners, Andres and Jose. They run such a great restaurant. The service is extraordinary. The atmosphere is great. So if you're in Pineville and the Alexandria area or passing through, or if you live there, go to Cabo Fuego and tell them the State of Freedom sent you. Blanco Brothers has been in business in Louisiana for about 30 years now. I have personal experience with this company, and I know others who have as well. If you have a business or a home and you've got roofing, gutter, sheet metal issues at all, one number you need to know, and that's Blanco Brothers Construction. He will treat you right financially, and he will take very good care of you with regard to the quality of the service that he provides. I cannot recommend Blanco Brothers Construction more highly enough. Memorize the number 225-226-4222. Blanco Brothers Construction, the very best in the business.
Thanks for joining us today on the State of Freedom. Any follow-up actions, resources, and links to our sponsors will be in the show notes. All calls to action can be taken at lacag.org. That's LACAG.org.
To learn more about our work, become a monthly subscriber, supporter, or advertiser at freedomstate.us. The State of Freedom, the #1 conservative podcast in Louisiana.